So, friends, the judge in the Abrego Garcia case is not backing down in the face of the Trump administration's refusal to act, refusal to facilitate the release and return of Garcia to the U.S. No. In fact, the judge is taking to task Donald Trump's obstructionist administration and his obstructionist Department of Justice. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, this new court order, just issued by Federal District Court Judge Paula Xinis, this is what the federal judiciary is all about. It's what our constitutional balance is all about. It's what co-equal branches of government are all about, checks and balances. And I'll tell you, friends, reading this court order, I kind of got justice goosebumps. Let's start with the new reporting, and then let's have a look at just a little bit, some select passages from the new court order by Judge Xinis. But first, let's start with the new reporting. This from the BBC, quote, "Nothing has been done," close quote. Judge warns Trump officials in deportation case. And that article begins, "A federal judge has given the Trump administration 2 weeks to submit evidence on how it is trying to return a Maryland man who officials have conceded was wrongly deported last month to a mega prison in El Salvador. Judge Paula Xinis accused government officials of inaction in the case of Salvadoran national Kilmar Abrego Garcia, warning there will be no tolerance for gamesmanship. She said she would decide if the government acted in good faith or was in contempt of court. The Supreme Court has ordered the Trump administration to facilitate the 29-year-old's release, though El Salvador President Nayib Bukele said on a visit to the White House he did not have the power to return him. On Tuesday, Judge Xinis told Justice Department lawyers at a Greenbelt, Maryland court hearing, quote, "To date, what the record shows is that nothing has been done. Nothing." And this quote from the judge, quote, "Cancel vacations, cancel other appointments," she said, adding, "I expect all hands on deck." She, the judge, said she would require 4 officials with the U.S. Homeland Security Department and U.S. Immigration and Customs Enforcement to answer questions under oath by 23 April. So, kind of looks like Judge Xinis don't play. Now, friends, let's go right to this new court order, and I want to read a few select passages to try to bring into full focus the nature and scope of the judge's order. In the case of Kilmar Armando Abrego Garcia, plaintiff, versus Kristi Noem, Secretary of Homeland Security, defendant, order granting expedited discovery. And friends, what that means in substance is that Garcia, through his lawyers, are demanding discovery, meaning they want to take depositions. They want to question Trump administration officials under oath to try to prove, to make clear that the Trump administration is in contempt of court, is violating not only the order of Judge Xinis, but of the Supreme Court, which affirmed that order. They want answers to interrogatories, fancy word for, having to answer questions, written questions under oath. They want the production of documents to be able to prove that the Trump administration is acting in bad faith, is failing to comply with, defying court orders, and is in contempt of court. That was essentially the request that Garcia, through his lawyers, made, and this is the judge's order granting, in large part, what Garcia is seeking. Order granting expedited discovery. Pending before this court is Plaintiff Kilmar Armando Abrego Garcia's motion for additional relief requesting expedited discovery of the government's actions or failure to act to facilitate his return to the United States. Specifically, Garcia seeks discovery as to the terms of any agreement, arrangement, or understanding regarding the government's, meaning the Trump administration's, use of CCOT to house U.S. deportees, his current physical location and custodial status, and what steps, if any, the Trump administration has taken and will take to facilitate Garcia's return to the United States. The Trump administration opposes the request, principally contending that the proposed relief is not consistent with the Supreme Court's order or the well-established meaning of facilitating returns in immigration law and harbors fundamental constitutional infirmities. For the following reasons, the court grants the motion for expedited discovery as directed below, but the judge notes that the court defers its decision on the remaining requests for relief, including the plaintiff's request that the judge commence contempt proceedings. More on that in a minute. The judge's order continues as she sets out the law and the legal standard that applies to this request. Upon a showing of good cause, the court may permit discovery where significant questions regarding non-compliance with a court order have been raised. It is undisputed that Garcia is entitled to injunctive relief for the reasons previously discussed and affirmed without exception. As to the scope of such relief, the Supreme Court of the United States unanimously affirmed that the district court's order, meaning the order of Judge Xinis, the district court's order properly requires the government to facilitate Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. To that end, the Supreme Court forewarned the government, the Trump administration, that they should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. This court, in turn, ordered no more than what the Supreme Court endorsed, that the defendants take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible, because bound within this remedy is Garcia's release from custody and the assurance that Garcia's case is handled as it would have been had he not been improperly sent to El Salvador. And then, friends, Judge Xinis goes on to give the Trump administration and the DOJ lawyers something of a third-grade tutorial, which seems necessary given the games the Trump administration has been playing, a third-grade tutorial on the definition of the word facilitate. Notably, to facilitate means to make the occurrence of something easier, to render less difficult, the judge says, quoting Black's Law Dictionary, the preeminent dictionary defining legal terms and concepts. But just so there's no misunderstanding, the judge decides to break out a couple of other dictionaries. Merriam-Webster defines the term facilitate to make easier or less difficult, to free from difficulty or impediment. And the Oxford English Dictionary defines facilitate as to assist a person, to enable or allow a person to do something, achieve a particular result more easily. defendants, the Trump administration, therefore remain obligated, at a minimum, to take the steps available to them toward aiding, assisting, or making easier Garcia's release from custody in El Salvador and resuming his status quo ante. But, the judge goes on to emphasize, the record reflects that the Trump administration defendants have done nothing at all. The judge goes on to conclude, the Trump administration, the defendants appear to have done nothing to aid in Garcia's release from custody and return to the United States. And the Trump administration's attempt to skirt the issue by redefining facilitate runs contrary to law and logic. So the judge rules that she will grant the plaintiffs, Garcia's, request for expedited discovery to assist the court in determining whether contempt proceedings are warranted. And the judge goes on to order up to 15 interrogatories, 15 requests for production of documents, 4 depositions, with 2 additional depositions upon request of plaintiffs, etc. Friends, this is what the federal judiciary looks like, working to hold accountable a co-equal branch of government that is abusing its power and authority. A co-equal branch of government that is acting lawlessly and unconstitutionally. But before we wrap up, let me take on one other thing that you may be thinking. This process of expedited discovery is going to take 2 weeks? That seems like an awfully long time. In fact, I'm sure it will seem like an eternity for Abrego Garcia, who is being confined at the request of the U.S. and at the expense of U.S. taxpayers, is being confined in a notoriously dangerous El Salvadoran prison where he should not be, and he would not be but for the lawless and unconstitutional conduct of the Trump administration. But for better or worse, friends, 2 weeks is light speed for courts and the legal process. But let's finish with this. Through this court order, and I'll put a link to this order in the description of this video, through this order, it is absolutely clear that to Judge Xinis, justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.